Let's take a look at agency employment. As a general rule, employers are legally responsible for the actions of their employees. When an employer grants supervisors and managers the authority to make employment decisions, the employer is liable if the employees use that authority to make employment decisions in ways that violate the law. The argument that the employer was not aware of the employee's actions or that the employee's actions were contrary to company policy will not save an employer from liability, although it might avert the imposition of punitive damages. Employers need to carefully select, train, monitor, and review the actions of their employees, especially those responsible for human resource decisions. There are bounds to the responsibility of employers for the actions of their agents. Employer liability is usually limited to employee actions taken within the scope of their employment. Actions are within the scope of employment to the extent that they relate to the kind of work the employee was hired to perform, take place substantially within the workplace and during work hours, and serve the interests of the employer. Harmful employee actions taken outside the scope of employment still might form the basis for employer liability if the employer intended the harm to occur, was negligent or reckless, or impermissibly delegated the employer duty. In some circumstances, a supervisor or manager can be held individually liable for violating an employee's rights, but this is generally in addition to employer liability.